So hiring an attorney does not mean that you're going to be jumping into litigation. And at Fenchel Family Law, we offer multiple levels of representation, including a consulting only, a limited scope, and a full scope if you were in litigation. A lot of times we help clients who come in and just need some legal advice as they're deciding whether or not they should file for divorce or separation. A lot of times before even filing, we can help clients guide them through mediation on topics such as division of property or in custody disputes as well. Mediation is where two parties collaborate with a third party who's not their independent attorney and talk about the issues that need to be addressed in divorce, and including custody, property division, and support issues. The mediation itself is non-binding. It's going to help parties come together and potentially reach an agreement. You can engage in mediation through a private mediator that you hire independently. It can be an attorney, it can be a retired judge, and it's a great process for two people who are looking to reduce costs of litigation, because litigation can be very expensive, very stressful, and it is recommended that you attempt mediation if you have an amicable relationship and that you do think it could be fruitful. We can help guide you through the process, and then if it turns to a point where you cannot agree, we can help you through the litigation process as well. The pros and cons of litigation, I'll start with the pros. The pros are you're going to get a result one way or the other. So litigation goes straight to the point. And to clear up, what is litigation? I mean, when we're in family law, we're talking about everybody to get divorced needs to file a petition for dissolution, and that would technically be litigation because you must respond to it and you are served. But when I think of litigation in the family law context, I'm thinking of are you going to be filing what we call a request for order? It's like a motion, as opposed to first working together and seeing if you can go to a mediator, see if you can negotiate with your attorneys or unrepresented to see if you can come to an agreement before filing that request for order. So the pros of litigation are if you cannot get along or you cannot come to an agreement, the court will make a decision for you ultimately if you file that motion, and we can help you file that. The cons of litigation include it can potentially increase your costs. There's going to be stress involved. You do need to go to court. You're going to have to respond to pleadings and hear and expose some of your issues to the court and to third parties by making filings and providing evidence. It really is dependent on your circumstance. So whether you go to mediation or litigation route, it's going to depend on multiple factors. Where you are with your partner right now, how amicable it is, what are the issues, and what your finances are and how comfortable you feel engaging in this process. Well, there's no specific time frame for mediation, and it can happen at different points in the process through divorce. It's not that you have to go to mediation first. It could be that you start litigation and you go to a private mediator later. Before trial, there's often a mandatory settlement conference, which is technically mediation because you're required to try to settle before trial. Mediation could also entail family court services, which is a free mediation that's offered before every child custody case. And that is a form of mediation that's required before the court will make orders in a custody litigation case. So the timeline can really depend and vary based on the circumstances, but no matter what, in California, you cannot be divorced by status within anytime sooner than 6 months. If you have questions about mediation versus litigation and what's right for you, give us a call.